Hello everyone, this is the video of Legal Studies, Class 12, Unit 3, namely Arbitration, Tribunal Adjudication and Alternative Dispute Resolution. And the topic that today I am going to discuss in this video is conciliation. By the time I have discussed about the ADR, that is Alternative Dispute Resolution, and its major types, that is arbitration, mediation, and in this video I will discuss conciliation. Okay, so let's first understand the meaning and concept of conciliation. Conciliation is a non-adjudicatory and non-adversarial mode of dispute resolution, okay, wherein an impartial third party, namely conciliator, actively assists the disputants to find a satisfactory and acceptable solution of the respective dispute. Okay, so what does it mean that there is a dispute, and if there is a dispute then there must be two parties minimum, okay, and in order to resolve the dispute, if those two parties willingly find or appoint a third neutral party who is known as conciliator, then the whole process starting from the appointment to settlement of the case is known as conciliation. Okay, so simple it is, and very similar to mediation that we have already discussed in last videos, remember? But there are differences. It's not like that it is exactly same. There are many differences. Okay, we will discuss that later. But keep in mind that there are differences between mediation and conciliation, mediation and arbitration, arbitration and conciliation, conciliation and litigation. So all these terms are distinct from each other. Keep in mind. Okay. Now, because of its compliable and flexible features, conciliation is considered as a meaningful and effective alternative dispute resolution method. Okay, by understanding such effectiveness, the Halsbury Laws of England defines conciliation as a process of persuading the parties to reach an agreement. Okay, so conciliation is a voluntary process under which both the parties with free will agree to resolve their dispute by hiring a third neutral party, namely conciliator. Conciliator is a third neutral party and he assists parties to find the mutually agreeable solution, and he has no authority to impose any of his decision or solution on the parties to the dispute. Okay, so his duty is only to assist, not to impose his own decision on the parties. He might suggest some of the possible solution, but again he cannot impose his solution or decision on the parties. Okay, clear? So like mediation, conciliation is also the mutual determination of the parties to amicably resolve their dispute through the ADR mechanism. All civil disputes usually are suitable for conciliation, and it is an excellent method of alternative dispute resolution for amicable resolution outside the litigative process. So what does it mean that this means conciliation is possible only with civil disputes, no criminal disputes. Keep in mind, no criminal dispute. Okay, so this is the simple explanation. So I brief it, that is the concept of conciliation. It is a method of dispute resolution out of court, okay, under which the parties themselves decide the solution with the help of a third neutral party who is known as conciliator. So simple it is, isn't it? Now, check out the law of conciliation. Conciliation as mode of alternative dispute resolution is recognized by the Section 89 of the Code of Civil Procedure, 1908. The section gives a reference to sub judice matters to conciliation with the consent of parties for extrajudicial solution. For extrajudicial resolution. What does it mean that? That is specifically sub judice, the matter which is inside the court or is pending, that can be with the interest of the parties resolved through the conciliation. The same section, that is 89 of Civil Procedure Code, also deal with the mediation, as we have already discussed while discussing the mediation. Okay, now come on the next point, that is process of conciliation. It is very much similar to mediation. Therefore, the process is also start in the same manner, that is with the appointment of a conciliator. There the parties need to appoint a mediator. Here the parties need to appoint a conciliator. However, check out the following steps that define the process of conciliation. The first step, that is appointment of conciliator. If any dispute arises between the parties, with mutual consent, both parties can primarily appoint a conciliator on ad hoc basis to resolve their dispute. See, since the method of conciliation or the process of conciliation is not an official or an institutional, so I have added the word ad hoc basis. So it is not a permanent. The next step is joint session. Secondly, a joint session takes place where both the parties, in the presence of a neutral third party, namely conciliator, discuss the matters, exchange the information. Okay? As per the requirement, conciliator may ask the necessary documents or other such proof and evidence in the joint session. Remember, mediator doesn't ask anything or any document, so you can find out the differences yourself. Just pay attention. Besides, conciliator can also suggest the possible solution by making them understand the negative consequences in case they follow the adverse path. Another difference, mediator doesn't suggest anything of such type, right? Okay, but conciliator suggests. So we can say that mediator is a passive agent. Okay, but conciliator is an active agent. Okay. Likewise, the conciliator helps parties to initiate and develop a positive discussion, clarifies the misunderstandings, creates trust on each other, and hence ultimately generates congenial atmosphere, which is essentially required for the harmonious and cooperative dispute resolution. Okay, I believe very much clear with these points. So I move forward. Interestingly, the conciliator may, if feels applicable, then in an amicable manner at any stage of conciliation proceedings, himself make proposal for a settlement of the dispute. Active agent, remember? So what conciliator doing? See, actively participating in that dispute resolution method, suggesting something, giving the proposal, okay, the best suited for them. Okay, likewise, he plays an evaluative role while supervising the process of conciliation. He attempts to get the parties to accept the merits and demerits of their cases, thereby leading them to a mutually acceptable solution. See, he is playing an active role in the whole process. The conciliator in this manner plays a more proactive and interventionist, which is not the property of a mediator at all. Okay, I repeat, the conciliator in this manner plays a more proactive and interventionist role in persuading the parties to arrive at a final settlement. Therefore, in actual practice, conciliator needs to be a person who is not only well informed, having the legal knowledge and diplomatic attitude, but can also potentially influence the parties by his persona and persuasive skills. See, so all these features required to be a conciliator, because although there is as such no defined qualification for a conciliator. But these features, as I have discussed here, that is diplomatic attitude, persuasive skills, okay, and good communication skill, everything is required to be a good conciliator. Okay, since we understood the second step, that is joint session, where the parties exchange their information, discuss their problems, okay, and accordingly conciliators suggest the solutions or propose something favorable kind of suggestion, etc. Okay, so now since the problem is discussed and they possibly find the mutually agreed solution, then they enter in the third stage, that is the step 3, and known as settlement agreement. Okay, when the process of conciliation successfully done and both the parties arrive on a common solution, then conciliator formulate the terms and conditions of the possible settlement and share that with the parties. Okay, so once both the parties agreed on some point, then the role of conciliator is to draft the agreement where he mentions all the terms and conditions, and after that drafted agreement conciliator shares with the parties, and after final discussion and approval with the parties, the settlement agreement is finally drafted and ensures that both the parties fully understood the terms of settlement. Once it is approved by both the parties, then both the parties sign over it. Once the parties signed over it, then it became the final and binding on the parties. See, focus on the term binding upon the parties. So it's not like that after signing the agreement they're supposed to be saying that, refusing to accept that and refusing to follow that. Not at all. It is binding. Interestingly, after signing up the settlement agreement by both the parties, the conciliation proceeding has the same status. See, another point that you need to focus on. Okay, has the same status and effect as if it is an arbitral award. So see how it is equivalent to an arbitral award. Not only this, a settlement agreement arrived in conciliation proceedings can be enforced by executing the same in a civil court as if it were a decree of the court. So see the execution part as well, how it is binding upon and how it is valuable and valid point basically. Okay, now let's check out some of the advantages of conciliation. Like other ADR methods, conciliation has also the following advantages: cost-effective and expeditious process. Are you agreed or not? Conciliation is definitely an economic and expeditious method of dispute resolution, especially in comparison to both litigation as well as arbitration. So even in comparison to arbitration, it is more effective and expeditious. Okay. The second advantage is autonomy and convenient for parties. It is one of the best advantages of ADR that gives freedom to parties to choose the venue of proceedings, to choose date and day of proceedings, and even to choose time of proceedings. Likewise, parties have full control over the conciliation procedure. Okay, so see how much parties are autonomous and how they decide their dispute. Okay. The next advantage is mutually agreed solution. It facilitates parties to find the solution, which is beneficial for both the parties. Likewise, parties can make an agreement with mutually agreed points and then, as per their convenience, can also define terms and conditions. Okay, the next advantage is confidentiality. The process of conciliation maintains the confidentiality of dispute proceedings, and even about the disputants. Likewise, no one can know about either dispute or dispute resolution procedure. So everything is supposed to be so confidential, and all the parties involved in this dispute resolution procedure also obliged not to disclose that to anyone. Okay, and the last but not the least advantage is enforceability of conciliation Settlement agreement. The settlement agreement drawn up in conciliation proceedings has the same status and effect as if it is an arbitral award. Okay, so likewise we have 5 advantages, that is major advantages and significant advantages of conciliation. However, like other ADR methods, it has not only the advantages but also a few disadvantages. What are those disadvantages? No legislation. Like mediation, it has also no provision and rules that define the proper means of conciliation and the proper methods, the procedure and everything. Therefore, it is less formal and less binding upon the parties. Okay, less binding in the sense that is before the settlement agreement, but once you sign the settlement agreement, it is binding, as we have discussed. Okay, the next disadvantage is lack of trust. People has more reliability on litigation than the conciliation, therefore it is less trustworthy. Least known. In spite of having so many advantages, the conciliation process is not known to many people of the country, and even who knows, he prefers to go for litigation. So it really needs some sort of awareness program. Okay, so this is all for this video, where we have discussed the meaning and concept of conciliation, the process of conciliation, and advantages and disadvantages of conciliation. So see you in next video with a new topic. Keep watching.